Let's start. The date reference has arisen from the judgment of conviction dated March 6, 2020 and the order of sentence dated March 7, 2020 passed by the learned additional sessions judge second court Puruli in session stat case number 01 of 2009. The learned judge had awarded the death penalty to the accused by the impugned judgment of conviction and the order of sentence fair. On April 12, 2008, the wife of the victim had lodged a missing diary in respect of her husband. On April 14, 2008, she had lodged a written complaint on the basis of which a first information report within the being number 65 of 2008 dated April 14, 2008 was registered under section 365 of the Indian Penal Code 1860. The body of her husband had been recovered by the police on May 11, 2008. The police had added section 302/201/120B/364 of the Indian Penal Code 1860 on July 4, 2008 to the first information report. Police had investigated the incident and filed a charge sheet against the accused. The trial court had framed charges against 7 accused persons on November 2012. The accused persons had been charged primarily within kidnapping and murdering the victim and destroying evidence relating to the crime. The accused persons had pleaded not guilty and claimed to be tried fair. Learned advocate appearing for the appellants has submitted that the prosecution could not establish the charges against any of the appellants beyond reasonable doubt. The prosecution had failed to produce any eyewitness to the murder at the trial. The prosecution had failed to complete the chain of circumstances so as to prove the charges as against the appellants beyond all reasonable doubt. Learned advocate appearing for the appellants has drawn the attention of the court to the contents of the first information report. He has submitted that the first information report does not contain any allegations of section 365 of the Indian Penal Code 1860. The commission of any cognizable offence has not been alleged in the written complaint. Considering the contents of the first information report, it has been contended that the investigating agency acted over jealously and that the appellants have been made scapegoats for a crime which they did not commit. Learned advocate appearing for the appellants has submitted that PW44, who was the alleged scribe of the written complaint, stated that he did not read over and explained the contents of the written complaint to the PW. Learned advocate appearing for the appellants has contended that although PW1 and 2 stated that they came to know from PW45 that the disease went to the appellants after being called by Topunwa, but such fact was not stated in the missing diary or in the first information report. Moreover, PW32 did not corroborate such claim of PW1 and 2 in deposition. Referring to the alleged recovery of the murder weapons and documents of the motorcycle and the pair of saddles, learned advocate appearing for the appellants has submitted that the prosecution could not place cogent evidence at the trial. He has referred to the statements of PW5 and Exhibit 60. He has submitted that Topunwa never stated that he would recover the murder weapon if he has taken to the particular place. Moreover, the witness to the seizure being Exhibit 60 being PW2 and 32 did not support the factum of the seizure. The pair of seized shoes claimed to be that of the victim was not recovered pursuant to the leading statement made by the appellants. Learned advocate appearing for the appellants has submitted that the existence of a jural relationship, assuming though not admitting that there was such a jural relationship between the appellants and the victim, then also the same is not an incriminating circumstance as against the appellants. The victim had other business also. If the existence of business relationship is a motive for murder, then other business partners of the victim should have been brought to trial also. In such circumstances, learned advocate for the appellants had contended that the order of sentence should be set aside and the appellant should be acquitted. Learned advocate appearing for the state has submitted that the prosecution placed relevant and cogent evidence at the trial to establish the guilt of the appellants. The prosecution has proved the charges beyond all reasonable doubt. Referring to the recovery of the dead body, learned advocate appearing for the appellants has submitted that the body was recovered from a septic tank of another person. The identification of the dead body is shrouded is mystery. The police did not send the dead body for DNA test in order to ascertain the identification. Learned advocate appearing for the appellants has submitted that there are major contradictions in evidence of the prosecution witnesses, and he has highlighted such contradictions. Urgent photostat certified copy of this judgment and order, if applied for, supplied expeditiously after complying with all necessary legal formalities. Stop. Thank you. Jai Hind. Jai Mera Bharat.